Hey folks, it's Gavin here from Sovereign Empowerment. Excuse my lighting, it's getting a bit late in the day. I'm joined by Randolph. Randolph is a fellow, how do we put this? Fellow awakened soul. He's been around the block a few times, let me tell you. Fellow litigant in person. He's got his own cases on. But what we're here to do today is Randolph's he's planted his flag within the arena of enforcement agents and everything that comes with what that is. And we've all had different experiences with that. And what Randolph wants to do today really is dispel a lot of the myths of what they can and can't do. And we really want to just pull the whole thing apart. So if you guys are in a situation whereby, and today's video, by the way, is going to focus on PCNs and warrants of entry with utility companies. We're going to do a separate video for council tax enforcement agents later on. So this is really just the types of, if you've got PCN fines and you've got enforcement agents involved in that, or if you're dealing with utilities and you're in the warrant of entry phase of things, how do we deal with that? Now, we're going to start with how to just nip the thing in the bud in the first place so you don't have any escalation where they're at your front door. We've all seen a lot of these different videos and heard a lot of different horror stories as to what can happen there. What do you do just at the very beginning just to stop it becoming a situation in the first place? And we'll just go from there. So with that said, guys, Randolph, welcome. How you doing?
Good evening, Gavin. How you doing?
I'm all good, my friend. I'm all good. Apologies for my lighting here. So,
No
yeah,
problem.
do you want to just want to kick off with where do you want to start with the utility companies and warrants of entry?
I think really it's all fines. Literally all these fines where you're told you've been fined, you've got to pay such and such. It's all really like an abuse because the system has done it how they do it. It's almost like bad practice has become the way
Normal.
of thing. Yeah. And if you want, we can take this all the way back to 1993, when in the House of Commons, the late Betty Boothroyd, who was the Speaker of the House, she literally turned around and had to put things straight and basically said to them, look, you're playing with words, but in any case, the Bill of Rights has not been repealed. Therefore, you cannot levy any fines. You don't have the authority to. Only a court has the authority to fine. So all of these fines that people are doing, it's literally working the wrong way round. So you haven't been to court, you haven't been convicted of anything, and all of a sudden you're being fined. And recently, Jacob Rees-Mogg, he stood up in the House and he basically said the same thing when they were talking about Boris. So he basically said to him, like, a notice, fixed penalty notice, there's no conviction between that. And there should be no smear on your character because you've been issued one. You haven't been convicted of anything. So he basically laid it out again. And what they're using, because put it this way, a lot of our situation is because we are not up to speed. See, when we get up to speed, they've got to correct their behavior. There's no reason for them to correct it because we don't know what their behavior should be. So we need to correct it. And what they're using most of the time is secondary legislation, but it doesn't trump primary legislation. And this is what Betty Boothroyd was letting them know in the House in 1993. And she basically said, it's a constitutional statute. It hasn't been repealed and it can't impliedly be repealed. So basically, the secondary statutes can, but the primary statutes, almost like your foundations. If you took the foundations away from your house, the house falls down. And that's basically what she's been outlining to them. And there's case law to support it.
So what you're, sorry, Randolph, what you're saying for people that don't know, if you're watching this for the first time and you're like, what on earth is Randolph talking about with Betty Boothroyd in Parliament? He's referring to the Bill of Rights. And it specifically states in the Bill of Rights, which is labeled a constitutional document. Now, I will just say, if you're regular on the channel, you probably noticed there's another video series going up about the Magna Carta. And we've got some comments that we're making in that. So if you've watched the video in its entirety, you'll know that I'm basically saying is that the Bill of Rights is still there and it's a very useful tool. And in this regard, it's brilliant because the Bill of Rights essentially confirms and it's grants of forfeitures, isn't it, Randolph? All grants and promises of fines and forfeitures, a particular person's before conviction are illegal and void. There you go. The end, right? So that's what Betty Boothwood was referencing. And now Jacobs Rees-Mogg has been referencing the same thing. So just wanted to clear that up. But please carry on, Randolph.
Yeah, I mean, he used another case, R.V. Hammer, where, it was handed down. So that was more information. Basically, what we're looking at is it's about we need to skill ourselves up. I try not to say they're doing this and they're doing that. You've got to take some responsibility. So basically, I'm looking at it as what is it that I don't know? And what is it that I need to know to deal with this? So you've got to be prepared to learn. You've got to be prepared to read, because that's how you're going to know. It's like being invited to a gathering in a house and you go in there, you don't like some of the rules. So what you decide is, I'm going to do my own thing. However, the host pull you up and they says, look, if you continue like this, we're going to have to fine you. We're going to do this. We're going to do that. And you're thinking, no way. But the point is, you're in their house and these are their rooms. So literally, you've got to create your own house and have your own rooms, or you need to understand the rules of that house so that you can challenge and you can find what your rights are within that house. And a lot of that you'll find also with the laws, the civil procedure rules, the criminal procedure rules. They give you information, but if you're not reading, you're not going to come across it.
It's, you know what, I think Dr. Graves says this as well. A good litigator is a good researcher. You can't litigate without being able to research and just look into this stuff. So if we keep this to PCNs for now, Randolph, what we're saying is that they are illegal and void, right? But equally, we can say, hang on a minute, if they're illegal and void and it's all confirmed in the Bill of Rights, why is this stuff even happening in the first place? And therefore, how is it we're supposed to stop it?
Yeah.
How do we stop this stuff escalating?
What you've got to do is you've got to try to nip it in the bud, in the notice stage. So once they write to you, you've got to now write back to them. So what you've got to do really is use your strategy. And your strategy should be, you are preparing for court. Although you don't want to get to court, you are preparing for court. So that's how your notices should be written. So basically, anything they write which you don't like, you have to rebut it and ask for the evidence. Once someone interacts with you, you have the right to do at least a data subject access request, especially if you didn't give them your details or you don't consent to them having your details. So you need to do these. And if it's a public organization, do a freedom of information. They're bound by statutes. These are the rules that they're bound by. So you need to use those rules because that's what they're supposed to abide by. And you get information from them. You need that information. It's vital for you to get that information to set up your stance.
So what we're saying here is, and there'll be folks watching this thinking, I don't want to go to court. There's that sort of fear factor with the court situation. Now, I know this is easier said than done, guys, but there's nothing to fear with court. You just got to get over it. We are in a situation, I think, at this moment in time with the way the system is right now, that they know people are waking up, that they're experiencing this because of the level of notices that they're receiving themselves. But the problem with that is that a lot of these are templates, right? We get a lot of the 3 lesser process and stuff like that. Now, whilst that used to work a lot, nowadays it's less successful in regards to the fact that if you don't know what you're sending, you don't really know where you're going with it, right? So where am I going? What I'm saying, you've got to be in a position where you understand pre-action protocol. Everything you're doing has an objective that you're escalating so as to go to court if you're not going to get your remedy out of court. But they know this too. They can see that there's an escalation to your pre-action protocol. And that's where you start to get leverage to bring these things to an end. Just wanted to clear that up, Randolph. So just back over to you. So if they're looking at writing their first notice or their DSAR, shall we say, to start exposing things, what are they asking? What are they looking for?
First of all, if it's a PCN, you're going to be faced with some bailiff or enforcement agent. So they're going to come at you with some bit of paper. Firstly, they don't have privity of contract. So have they bought the debt? Has it been assigned to them? If it has been assigned, there are rules for that assignment. So there are ways in which they need to communicate with you. So number one, it has to be by recorded delivery. That's the rule if you're going down the road of assignment. And it's all contained in the Law of Property Act.
Law of
Now,
Property Act 1925, folks, just in case you
1925, sorry.
Okay.
Yeah. So then that's the first piece of information you want. What they're going to try to do is fast forward you to the point where we want to visit you because we want to get to your goods.
Actually, just one more thing, if I may. Sorry, Randolph, just to clarify it for people. We're asking these questions on the understanding that we know that there's neither in place. There has been no assignment because there is no debt, because it's all illegal under the Bill of Rights. And there therefore is no contract either. And what they typically try and reference is they're dealing with their client. They're working on behalf of their client. And they say that so as to disempower you, to make you feel like you have no choice here, but to pay them. So just wanted to establish that. They basically are asking questions because we know neither of these things exist or have happened.
Yeah. And at the end of the day, you've got to go back to the basics, to the start. How did this start? The start was not correct. It was an abusive process. So everything after that falls away. Now, they may stretch you out for a little while. You may even think that, oh, what I'm using is not working. It's not that it's not working. In some respects, you're dealing with people who are following what they've been told, but don't themselves actually know the law.
Yeah.
And it's not their fault. We've been done on both sides. And that's so that they follow the script. Because if they knew the law and they knew you were going by the law, they wouldn't be so committed, so it wouldn't work. So they themselves are being subject to PCNs and whatever fines, just like you are. So in their mind, why is he trying to get away? He should just pay like everybody else.
Just as a side note, it's the perfect prison that they've created for us, because we essentially, the people, imprison ourselves. We are the guards of our own prison through ignorance. And that's exactly the situation. And we've all experienced that with enforcement agents or even police in some cases as well. So yeah, sorry, Randolph, we're dealing with it from both sides. Can I ask a quick question again? I'm just thinking about the folks that are watching this video, maybe looking for answers that have never really heard of any of this stuff. You mentioned abuse process at the very beginning. What do you mean by that?
Most cases can fall away because of abusive process, because there is a process you need to go through to bring a claim. There is a process you need to go through for a warrant. So, for example, let's say someone's applying for a warrant. Now, what rule or what statute are they using to apply for that warrant? What criteria must they meet to gain that warrant? Now, you don't know what they used. So that's the information you need to find, because they may not have used the right criteria. For example, a lot of times is you can enter someone's home under health and safety, which comes under criminal, but you're really dealing with a civil matter. But are you aware of it? Then has the information been submitted? Is that information correct? You don't know. So you need to get that information. Now, seeing as they're coming into your home, you're a party to whatever they went to the court with, because presumably they're using your name. So you have a right to access all that information. So you can find the information that was used to claim against it. And I think a lot of the times people are not aware that they can access that information. So that's the first hole, because you don't actually know what you're dealing with.
So like the trick thing with a DSAR, and again, for those of you folks that have never heard of this before, you're drafting a DSAR under the Data Protection Act 2018. Now, to oversimplify that, you're requesting your data and information, and data and information can be as simple as your name. Randolph, that's your data. So that then becomes your property. That is your property, which means that if you think about how you craft the questions, then you can catch them out. As an example, we talked about the contract, right? So if you've done a DSAR and you requested your data information contained within the contract, as an example, knowing that they don't have a contract, by default, you've got them into a position where they can't comply with the request. So how do they respond to you? So think about it like that. You're always looking to get leverage with the DSARs that you do. They're useful in their own right, but they're also useful as a litigation tool. Did you want to pick up on that in terms of what are we asking in these sites? If we kept this, we've got two sort of scenarios here. We've got the types of agents that turn up with the warrant of entry, which is utilities. And then you've got the agents that turn up for PCN fines, for whatever they may be. So if we tackled the PCN fines first,
Yeah.
what are we asking in this DSO? What are we looking to expose?
You would basically want all the information that led to this situation. So, for example, they have the use of your personal data. And what you're trying to find out is how much of that data they have and how they're using it. Because when you gather data, it should be for a specific purpose and it must be for a certain amount of time. Now, if you gather it for one purpose and use it for another, you're abusing the process. You're not supposed to do that. So you can also correct your data if someone is holding data that's incorrect. You can actually ask for your data to also be erased under the Data Protection Act. But people need to read it so they can see what leverage they have here. So you want all the questions that exposes, is there an agreement with my name on? Is there a contract with my name on? How did you access this information? I've never given you a phone number. How did you get my phone number? Because people are telling me now, agents, never ever you gave their phone number. Hey, we're buddies. I'll be coming round tomorrow at such and such. Make sure you're in.
And think about it this way, guys, like these enforcement agencies, bar a few that I can think of, are limited companies. And this is why the Data Protection Act is perfect, because it obviously governs how these limited companies are processing. But then you've got to think about if this limited company is coming against you, where is their right of claim against you? So we've already established a PCN fine is illegal, right? The Bill of Rights is very clear and it's been upheld quite a few times. And there's actually even the metric martyrs judgment, isn't there? Case law that confirms that the Bill of Rights is a primary statute and therefore supersedes the legislation that they would be using to do this. And a lot of the time, the PCNs are done under the Road and Traffic Acts, I believe.
Yeah, you get 1991, 1984, 1988. The point is they're void from the start because the way they were implemented is incorrect.
They have no authority, and that's your abusive process.
So anyone from that point acting on that or trying to enforce it, it's all void. Now, usually the fear is based on what you don't know. That's your primary fear because they're coming and you don't know how to deal with it. Once you realize that, you will then mentally, you view it differently. That's just how it goes. When you lose the fear, you view it. If they were to turn up, first, I need your ID. But first of all, for example, if you were a woman inside and two big strapping lads turn up to your house, you don't really want to be going down there to open the doors. And you don't have to because you don't have anything with them. They're third-party interlopers and they're trying to make some money based on your fear and your ignorance. But if you're someone who wants to challenge it and wants to open the door, then make sure you have at least minimum 2 people with you. Record it, voice record it, take a picture of their ID. If you've got access on your phone, you get that ID and you check the certified bailiff register straight away. Are they on there? Are they on the Financial Conduct Authority? Just check them out. Find out what authority they're coming with. So first of all, do they have the authority? And is the piece of paper that they're coming at you with, has that got any weight? Now, the fact if you abuse the process, it has no weight right there. Then sometimes what they may do is clamp your car. Do you have a license to clamp? Because you need that license under the Private Security and Industry Act to clamp. So do you have a license?
And by the way, guys, this is not the bailiff license that you can check on the bailiff register for. This is a different license that they need for clamping vehicles. And actually, you can always tell when they don't, because 99% of the time they use clamps that you can buy from Halfords. If you literally Google wheel clamps, you'll see the typical kind of like horseshoe thing with a bit sticking out the bottom. They tend to use those. Whereas if they're licensed, they're meant to use the same type of clamps that the police use, right? The ones that cover the entire wheel, that completely immobilize the vehicle. They don't use them. So if you want an obvious kind of proof point that they literally have no right to be at your property doing this stuff, There you go. But imagine they're clamping with that kind of clamp, no license, and on your private property, which happens all the time. Right. So when you see this sort of stuff going on, you can almost goad them into this, because the more they do, the more liability they assume, the more you can do to them in return. Sorry, I keep jumping in here, and I'm
That's great.
excited by this stuff as well, guys.
Well, basically, if you look at it another way, you can buy these clamps. You can put clamps on your own car as a form of immobilization and security.
You can clamp their car, their vehicles as well when they turn up if you want to.
Yeah. You see, when they turn up also, if they turn up in vehicles, are those vehicles insured for business use?
Indemnity insurance.
Yeah. And if you use, when you arrive into them, you can conditionally accept. And basically you can, if it's a contract, let's look at it this way. If it's a contract, shouldn't I be getting something out of this contract? So you put in the terms and conditions in the contract that you like. They've got the terms and conditions that they like. You can agree if they can agree. They agree, you put your fee schedule in. This is to protect me. This is my fee schedule. You agree. Now we have more of a meeting of the minds. But as it stands, if there's a supposedly contract, did you have any part in it? Did you do any negotiation? Most times, no. So how was there a meeting of the minds?
Therefore, no contract.
Right.
So let's just play a role play out for people, right? And let's just say PCN, fine, you've got one today. What are you doing about it? What's your first move?
So if you got the PCN fine, what you would do, you would put your notice together, try to keep it as brief as possible to the point.
What are you asking in that notice? Sorry.
Basically, you'll be asking for any information. So, for example, chances are no one's going to sign it. So who do you write to?
Yeah.
Where no one signs it, then you have a right to write to whoever owns the company or whoever is running the company, because ultimately they're responsible. So you may need to go to them and say, look, I've received this. No one's taken liability. It could be a fraud. I'm not too sure, because I'm sure if you wrote to someone and didn't sign your name, how would they know? So how does it work the other way?
So you go, basically what we're saying is that the DSAR you could send to the base protection officer, but essentially you're looking for the most senior individual within that organization, whoever they would be.
Yeah. People are moving away from giving their names. Tells you something's wrong, doesn't it? If you were standing in your right, hey, I'll give my name. I actually believe in what I'm doing is correct. I'll give my name.
Yeah.
Now, if your manager, as you hear, oh, our manager said we must give our surname. Why not? There may be 2 Jameses working in that department. There may be 2 Shirleys working in that department. Who did I speak to? Meanwhile, you're asking me for security. I've got to give you full name, address, postcode, date of birth, maybe some other type of security that you've set up that I should know. And meanwhile, what have I got? I've got nothing. But aren't we all equal under the law? So who should I say I was being speaking to? Where's your liability in this? What happens if you mislead? What happens if you're not doing what you're supposed to be doing? Malfeasance. In a public authority, they're supposed to abide by the 7 principles of public life, otherwise known as the Nolan principles. That includes integrity, transparency, accountability. Where is that? So, when you have your manager telling you not to give that information, what kind of outfit are you running? You should, if you're selling a brilliant product and you know what you're doing, you'd be proud to put yourself out there. You're advertising. And if you can do that, most people, I'm wrong. Hey, they gave me all the information. I had to put my hands up. I was wrong. It's not what's happening. Seems like we're going around corners playing hide and seek.
Yeah, they very much don't like their names being put out there.
And ultimately, when there's once it's void from the start, any coming to your house is trespass. That's a trespass. You can send them a removal of implied right of access. You can put out trespass notices. People tend to think, that usually goes up because someone's maybe got an estate and he's got land at the gate for that. No, you can put that out from your gate. You don't need anyone disturbing your peace. That's why the police turn up. That's what they're supposed to be protecting.
Yeah, breach of the peace, your peace. Yeah. Just on that implied rights of access, 'cause I've actually had this a few times with different folks. They will ignore that. So when like that's the you got to remember if we take a step back in this whole PCN thing, the Bill of Rights is saying they're illegal and void. Yet we have an industry here that makes I couldn't even say it's obviously multiple millions. I was actually reading a report in the mainstream news today, just bringing this in, that the profits bailiffs in the last year have gone up 50%. If that's not telling you something, I don't know what does. But the point is, they've gone up, yet all of this stuff's illegal, yet it's being facilitated by the same system that also says it's illegal. That's the situation we're in. But at the same time, you also understand the situation. So when you've got the implied rights of access or removal of implied rights of access, you might send it into these guys as well. And they will likely come back and say, there is no removal of the implied rights of access. We've got an absolute right of access, and here's why. You've got to understand your position. Randolph's been saying it's not about what they say. They're not going to admit any liability here because the whole thing's a scam. And the moment they go, "Oh, yeah, you're right," they're admitting liability. You can go get them. So they're going to double down. I always say this to people. It's like when you catch a liar lying, there's two ways that can go. They're either going to put their hands up and admit it. Now, the only way that really generally happens with a liar, and it's the same for all of these people, is if you've given them a soft exit whereby they know it's not going to bite them in the backside. But 9 times out of 10, a liar caught in the lie is going to double down on the same lie. And that's the same thing with these people. So you've got to understand your position and why they don't have any rights to be there. Not about, oh, they're saying this, that, and the other to me. I'm doomed. It's all over. It's not about that. If you know what's really going on, anything they're saying back is just more evidence for you when you go on your counterattack. So if we bring that back to that D-star, Randolph, got a PCN, right, what am I going to do? We're hitting them with the contract because we know there isn't one. We're hitting them with the notice of assignment because we know it's not been assigned. I'm assuming you'd put a deed of assignment question in there as well, provide the deed of assignment, because if this is coming from one organization to another, there's either a contract expressing third-party contract rights or there's an assignment of the alleged debt. And obviously none of that's taken place because it's not real, it's all illegal. So we've got contracts, we've got notice of assignment, deed of assignment. Would there be anything else you'd want to put in there? How they've obtained your data, how they're processing your data?
Yeah. I mean, what you want to do is you don't want to get into writing these long notices. You want to keep it focused. Because remember, you can write a simple notice, get some information. Right, I've got that. Write another one, get something. To avoid putting a load of information in one, just gather it bit by bit, gather that information. And when you keep it simple, it's hard to detract from the facts. This is why I ask you, are you incapable of responding to a direct question? Because I'm questioning who's at the other end doing this job now. It's very simple, but they will try to ignore it because there's nowhere to go.
Yeah.
So they will try to ignore it.
So the PCN then is illegal and void. I'll give you this now just to do your own research because it's really important you understand why. So you've got the Bill of Rights. So go through the Bill of Rights, read the Bill of Rights. Directly connected to the Bill of Rights, you've got the Act of Settlement 1700 and you've got the Coronation Oath Act. So go through those, read them, consume it, understand it. Get to the section about grants of forfeitures. I know Randolph wants to say something else. I'm going to just end this in just 2 seconds. And then the other thing, you can find this on Google. It's so easy. The Metric Martyr's Judgment. Find that too. Because when you're dealing with these people, they normally come back and go, oh, that's not relevant. We've got the authority under this piece of legislation. So you generally need that to just blow the whole argument out the water. And generally with the PCN at the very beginning, if you've got that right in the notice, it's dealt with in the notice and it won't go any further. Sorry, Randolph.
Yeah, I was going to say, when you're getting good at this, you will know because you're going to be reading the information that's been sent to you and you're just going to pick holes in it. So, for example, you've received this PCN or whatever fine, and it's going to say someone believes. So the organization believes. So is it a fact or not? See, what you've got to realize is there are a lot of presumptions. And this is why you must rebut the presumptions and gather facts as evidence. Ultimately, if you end up in court, the judge shouldn't be concerned with anything else but facts, evidence. So what you believe, what you presume or assume doesn't push that to the side. Then the presumption is going to stand as truth because you've done nothing. And that's basically what they're coming at you with most of the time. Presumptions. You've got to push those to the side, rebut and answer the evidence. That's what you need, hard evidence. And once you start asking for that, people start running away because they don't have the hard evidence.
Yep, exactly that. Always push for the evidence and the facts. And just on the Bill of Rights and why this is, please correct me if I'm wrong or if you want to say anything else, but essentially the reason the court piece needs to happen is that it's a sum of money that they're trying to enforce on you. And in this system, unless that sum of money has been adjudged as a debt in a court, you can't enforce it. You can't come after people for it. But what's happening with the PCNs is that's exactly what's going on. They're essentially adjudging you out of court, saying you're liable for this figure, and then they're instructing enforcement agents to come and enforce that amount of money on you. That's why the whole thing's illegal, because it breaches so many other things, even the Bill of Rights, but you get into debt pre-action protocol and all the other stuff that goes with it. It meets none of the requirements of any of that. Is there anything that I've missed there, Randolph, or anything you'd want to
Well,
come
this
in
is
with?
why it's an abuse process, because it's actually working the wrong way round. So ultimately, after all of this, someone states, oh, we're going to take you to court. Oh, now you're taking me to court.
Yeah.
So who had the authority for this fine in the first place? If you're now looking for the authority, back it up. They're not courts. Where did they get the authority over court?
And if it's a council PCN, remember Section 78(2), Local Government Act 1888, the council cannot act as the judiciary. They can't do this stuff. And this is exactly what's going on. So these are very simple pointers that you can very easily just Google and validate yourself. And then you start to put that together into a notice. You've got all the facts there. And it's now that if they ignore you, you're building your case. They can't then later say that they didn't know. You've expressed all of the facts of the matter. They're ignoring you now and they're carrying on.
The big question is, how did the people find themselves in this position? How did we move we the people, the creditors, to we the people, the debtors? How did that happen? How did your public officials or public servants move you from beneficiaries to trustees? That's a deeper discussion.
Big discussion.
Well,
and actually on that, guys, well, just if you want us to do that discussion, leave a comment because we can dig into that. Everything's an implied trust, basically. It's another conversation, but that's another level to this matrix that we find ourselves in.
Yeah. But I would say always keep it simple and keep it factual. That's your evidence. Anyone can make a claim against you and anyone can say what they want. When it comes to actually backing it up with evidence, now we'll see what we've really got. Exactly. Like this was around the 2008 crash when I listened to a discussion on Radio 4. And at the time, some of the banks, the economists, because the economists were telling them what would happen if they continue down this road. So one of the economists, he turned around and said, because they were finding the banking system complex to understand the truth behind it as opposed to what you've been told, he says, not to worry. When the tide goes in, we'll find out who was swimming without trunks.
Yeah, so true as well. So true.
Yeah.
So, right, we've covered the PCN. Do you want to talk about the warrant of control, or do you want to leave that for the next video? Not the warrant of control, the warrant of entry. I apologize.
Warrant of entry. Basically, the warrant of entry is, why are they asking for a warrant of entry? Why is someone trying to get into your house to levy goods? Is it a criminal matter or is it a civil matter? So how do you get into someone's home for a civil matter regarding the debt?
You cannot, unless you are a scammer like these buggers are.
Yeah. So what do they use to get into your property? Even if you look at the Electricity Act of 2006, it states that even the government, I think, came out and tried to stem the flow of these people going into people's homes and putting in smart meters, because it states that there must be a contract in place. You must have agreed to have, but we've got to get up to speed to read them. And to enter for a criminal matter, you must supply an affidavit. So when you go to the court and you want information because you're party to that. You want to see that affidavit. You want to see who signed it and who's in the justice of the peace who signed it off, or the justice is clear. Who signed this off?
Remember, these are all public officials and they have an obligation to provide the names of these people. So when you put these requests into the court, whilst they might try and obstruct you and do everything they can to stop giving you the names, they ultimately have to give you these names.
Ultimately, this is why you have to do a bit of reading. You have to do a bit of research. We can help. You've got to be willing to find your way.
You've got to unfortunately put some work in to find this out. So if you're looking at like the warrants of entry specifically for utilities, like civil, it's like Randolph was saying, right? How can you get into somebody's house for debt? Now, whilst all of your correspondence, if you're battling, will be about the debt, when they turn up at your property, it's going to be as a health and safety matter, because they use, what is it now? They use, rights of entry, gas and electric. I think it's 1954.
And I mean, under the rights of entry, I think everybody or the majority of people would agree. So, for example, you've gone on holiday, your neighbor passes and smells gas coming from your property. Someone else passes, smells gas. Well, we've got to put in an emergency call because there's gas coming from it. So
that's what that was used for originally. That's what it's meant to be used for, isn't it?
Yes. So you're away. So they have to go to the court to apply for a warrant under health and safety, because it's in the public interest to secure that and stop this gas leak, because it could cost a loss of life. So they do that. They break into your property. That's where the criminal damage comes into it. They change your locks, because they're only supposed to drill the locks. They change your locks, and they put new locks once they've secured the supply. When you come back, you will be informed. There'll be new keys. You could add more locks if you want, but that's what it was for. It was for to protect the public, and it's in the public interest. And I don't think most people can actually have a problem with that.
I would agree, the same thing. But unfortunately, what they've done is they're misusing that legislation to use fake. And if you've ever done this, guys, when you use DSARs and you get the evidence and you get these fake bullshit warrants, you'll see that they have a cut and paste section as to the health and safety situation. And when you've done it enough times, like Randolph and I have, they all have exactly the same health and safety situation. That can't be right, can it? All these countries up and down the country, the same problem. And then the other thing is, like, when they know that you're there, which they will done because you have been back and forth with them, there's a procedure, right? There's protocol, there is process they're meant to follow to put an application in so as to obtain that warrant. And they're not following that. That's the point. And this is where you can nip this stuff in the bud again at the beginning, when you've done the research to know the process, knowing that they by possibility can't follow it to obtain the notes, to obtain the warrant. The way, I don't know if Randolph does the same thing, but we let them know what the process is. Yeah, that we're happy for you to follow the process, but obviously we're allowed then to see the complaint, and we're allowed to object to that complaint in a court. We're allowed our day in court. Article 6 Human Rights Act, which is a brilliant piece of legislation that Randolph gave me, actually. You're allowed your day in court to defend this stuff, but by impossibility, they're not doing this, because if they did, they'd never get the warrants. They'd never get done what they want to do, which is get in your property and change the meters. That's essentially it. Sorry, I'll keep taking over, Randolph.
No, that's quite right. The explanation is what's needed. It's like Lord Delian said, you call something or nothing and expect it to stand.
Correct.
That's why if it's void from the start, it's void all through.
So these warrants by default, every single one of them are void ab initio. No, and this is the other thing. The way they obtain the warrant is 100% administrational. They go to that fake business centre thing up in Northampton. There are no judges or any qualified legal people in that business centre. It's all done administratively. And that itself is unlawful. No one with any legal training has applied their mind to any complaint so as to ascertain that there's substance here and this needs to be granted. It can't happen. And again, because why? The original purpose of the Act was health and safety matters for dangerous situations. And they're subverting that for debt matters, to break into people's homes. This is what's going on.
And you'll find a lot of the elderly got taken advantage that way, because there's a sense that you're in a position of authority. We expect you to be doing the right thing. But a lot of the times now we have to say, are you doing the right thing? Are you following the procedure? And that's where we became a little ignorant, because we thought they would be following the procedure and they would be doing the right thing. But who is overseeing that?
Yeah.
How do you know something's right if you don't know the rules?
Correct.
We have to get to know the rules.
And we've just got to get better at what we're doing, people.
Yeah.
We now know we're in this situation of tyranny, and it's really upon every single one of us that sees this to now step up and start doing the work, start learning how this stuff works. As you probably know with the videos that I've done, I look at this legislation and everything. It's just tools that we need to fight the fight on your front door. And it's like Randolph was saying at the very beginning. If you get in at this at the beginning and you know what's going on, you can nip it in the bud. And all of these situations that we've seen online, the videos, none of that escalates to that situation because you killed it at the very beginning. So to give you an example, if you know the procedure or the process that is meant to be followed to obtain the warrant of entry, and you've noticed them before they've even done it, that here's what you're going to do and here's what I'm expecting and yada, yada, do you think they're going to proceed with the warrant of entry? No. So you've diffused that before it became anything. And then the same thing again applies to the PCN. So I know this is easy. It's easy to do, right? It's easy to do when you know. And the message that Randolph's really putting out is that it can be done. You've just got to do your homework.
You've got to be willing to do a bit to learn, because if you think about it, we weren't taught the rules of the law of the land in school. And we should have, shouldn't we? Because we're all here.
Yeah.
So why weren't we taught that?
To be frank, if they did, I don't think we'd be in the situation that we're in now. We'd all be litigating, and none of these people were doing any of this stuff. It wouldn't have been able to manifest to what it is.
That's right. And this is what, it's like anything, it goes so far, then you've got to draw it back. It's like the balance of nature. We can go so far, and it gets drawn back.
Exactly that. So I think what we'll do, guys, we'll bring this video to an end. So Randolph is actually now one of the guys in Sovereign Empowerment, and he wants to help with his knowledge. We help you guys with his knowledge with regards to enforcement agents. And we're going to be doing another video specifically on the council tax enforcement agents and literally how they have no power to do anything and how you can just stop anything manifesting into something bigger. But if you've got any specific questions, if you're dealing with PCN fines as an example, and you're a little bit further on, right? So it's all well and good us saying, hey, you can nip this in the bud at the beginning, just go learn some stuff. But you might already be in a situation that's got bigger. Randolph is available for calls now. So feel free to book a call. Randolph will go through your situation and he'll offer the advice as to what he would be doing in your situation and what you can then do to rectify it. And if needs be, this would be between you and Randolph, you can talk about potentially him assisting a little bit more hands-on. And the same again would be going for the utilities. So if you've got any questions, you want more information, feel free to book a call with Randolph. But with that said, if there are any further questions, please leave them in the comments. If you want more information on this particular topic, again, leave it in the comments. This is what we need for feedback to know that we're doing the right stuff. We're giving you the right information. Because there's no point us putting hours into these videos if the information we're giving you is not going to help. We're here to help and provide the right sort of information. Do leave us some comments. Let us know if this is the right sort of stuff. If there's anything else you want to know, again, leave it in the comments. And with that said, we'll see you on the next one. Randolph, thank you, man. Thanks for your time.
You're welcome, David. Take care.
See you.
All right. Bye.
Do you find the legal system overwhelming and wish you had the knowledge and skill sets to control judges, persuade attorneys, and win your case? Well, look no further. Sovereign Empowerment is proud to announce our partnership with Dr. Frederick Graves so that we can bring you the Jurisdictionary Law course, How to Win in Court, your ultimate resource for mastering the courtroom. Unlock powerful case-winning strategies as you learn to control judges like never before. This comprehensive course eliminates guesswork and empowers you to navigate the legal landscape with absolute confidence. With step-by-step instructions, flowcharts, and outlines, you'll have all the tools you need to persuade and control judges in any case or court. Learn from a seasoned attorney with over 40 years of winning experience, who has distilled his expertise into this comprehensive program. Access everything you need in one single package, including sample forms, video seminars, audio clips, and in-depth case-winning classes. Learn at your own pace, anytime, anywhere. Our 24/7 online access allows you to tailor your learning experience to fit your schedule. Access the course on your smartphone, tablet, or computer and become a legal master whenever and wherever you want. Benefit from a suite of powerful tools, including a free online legal research tool, a legal dictionary with common sense definitions, and an exclusive Q&A forum to connect with fellow students and obtain expert guidance. Good people have suffered too long at the hands of power because they just didn't know how to fight back. Now, in a matter of just a few days, you can acquire the tools and knowledge that takes law students years to achieve. Can't afford a lawyer? No problem. With the Jurisdictionary Law course, you'll gain the skills to win your case without expensive legal representation. Alternatively, equip your own legal consult with the tools and tactics to fight effectively on your behalf. Level the playing field and secure your victory. No matter what court, civil or criminal, conquer any courtroom challenge with ease. This step-by-step guidance ensures a quick and straightforward learning experience, empowering you to navigate the legal system with bulletproof confidence. As a testament to your newfound legal expertise, you'll have the opportunity to complete a final exam and receive an honorary law degree upon successful completion of the course. Showcase your achievement and establish yourself as a force to be reckoned with in the legal arena. Dr. Graves believes everyone deserves access to legal knowledge. That's why we offer the Jurisdictionary Law course at an unbeatable price. For less than the cost of a 1-hour legal consultation, you'll gain unlimited access to this complete program for up to 2 full years. Take control of your legal battles without breaking the bank. How to Win in Court has become the most trusted law course worldwide since 1997. Don't miss out on this exclusive opportunity to gain the upper hand in the courtroom. Enroll in the official Jurisdictionary Law course today and unleash your legal power. Click the link in the description below to become legally empowered today.